welcome again, everybody. This is Options for Artists and Entertainers. My name is Fuji Whittenburg. I'm an attorney here at Wolfsdorf Immigration Law Group. We have offices here in Santa Monica and in New York. So what I'll do is I'll go through the PowerPoint and the presentation, and then throughout I believe there's a chat function so you can ask questions. If I see something, and I may answer it while we're going through the PowerPoint, but otherwise I'll try and respond to your questions afterwards. And then feel free to also email me. My email address is at the end of the PowerPoint. You can also find my email address at our website, and you can go to our website and log in and register to receive our newsletter and any other updates. You can, feel free, obviously, to like us on Facebook and follow us on Twitter, all of that fun new media stuff. And then also one last thing, obviously, this is not meant to be, direct and specific legal advice. This is for informational purposes only. And, as some of you are probably familiar with immigration, it's very, very case specific. So, again, this is just general information that we're providing to you, but I'm more than happy to review your resumes or credits or CVs to see if you qualify for any of these options. Okay, so let's get started. The main visa category for artists and entertainers is obviously the O visa, and then we'll discuss the P visa, and then we'll save, the best for last. We'll talk about the green card EB1 at the end. And so the O visas for aliens of extraordinary ability, there's the O1A classification and O1B. So for artists and entertainers, almost everybody will fall under the O1B category, which has a lower standard. It's still high because it's still extraordinary ability or extraordinary achievement, but it is slightly different than those that are in the science, education, business, or athletics. Fashion models sometimes are considered to be in the O1A category. There's a case about it, so I always throw that in there. But these are the two main categories, and then within O1B, there's the arts or motion picture TV. Motion picture TV has its own set of criteria, although they are virtually identical to the arts. The wording of the standards are slightly different, so we'll get to that next. And then it's worth mentioning there is an O2 visa category, which is for essential support personnel in connection with an O1. So you can't get an O2 without an O1 that you're connected with. So it's not a completely separate category. And then O3 visas are for dependents, so family members, spouse, or children. And there's no work authorization for that visa. So the two standards, since this is about artists and entertainers, we're not going to talk about O1A. So just within the O1B category, there's arts and motion picture TV. I have the standards written here. Again, it's when I read this the first 10 or 15 times, I don't see the distinction at all. The wording is very similar, but there is a difference. There's a line that they draw. So O1B in the arts means distinction, which is demonstrated by a high level of achievement in the field as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And that sounds onerous, but at the same time, ordinary people haven't appeared on television, even if it is, I use that argument a lot, though, saying that, ordinarily, somebody wouldn't have this, or, ordinary. That's kind of easy to overcome, ordinary, even though it does sound a lot harder than it may be, I should say. And then the buzzword there is also that they're recognized as being prominent. So prominent means renowned, leading, or well-known. The O1B, film, motion picture TV, or film and TV, the alien must be recognized as having a record of extraordinary achievement. So arts is extraordinary ability. Film and TV is extraordinary achievement. So that means a very high level of accomplishment in the motion picture TV industry and having skill or recognition significantly above. So you see O1B arts was substantially above. This one's significantly above. You say tomato, I say tomato. I know it sounds very similar, but apparently it's not, because to them that then means you have to be, outstanding, notable, leading, which, again, it's a matter of argument and using the correct language. So then how do I qualify? What are the criteria? So in the regulations, they provide this. You can also find the regulations listed on the USCIS website. That's uscis.gov. And you can go and find the 01 standard. So again, 01B is lower than 01A. But it's either, I get this question all the time. People are like, oh, don't I need to show that I've won an Oscar in order to qualify? That's not necessarily true. According to the regulations, the criteria is, either a major award, so an Emmy, Grammy, Oscar, DGA, SAG award, or 3 of the following. So most people, qualify under 3 of the following. So you have to meet 3 of the following criteria. And so I'll go through them now and kind of give my thoughts. Performed and will perform services as a lead or starring participant in productions or events. So this is, being the lead actress on a TV show, or being, the headlining band at a music festival, at South by Southwest or something, or just being, one of the headlining bands, or maybe even just being, at South by Southwest is a big enough deal. But that's, performing or has performed and will perform. The second one, achieved national and international recognition for achievements as shown by reviews or other published materials. So this would be press or reviews. Again, for musicians or artists, or, a review of your television show or the movie or the short film at a film festival, and this includes online press as well as, hard copy magazines and newspapers. Everything is, a lot of things are online now. So press, so 1 is credits, 2 is press. The third one looks identical to the first one, so lead, starring, or critical role for organizations and establishments. So the first one was for productions and events. This third one is for organizations and establishments. So let's say you're the lead actress on on Parks and Recreation. That would be the production, and then the organization would be NBC Universal. So you could say, if by being the lead, or like having a starring role on one of their more popular shows, you somehow had a kind of a starring role for NBC Universal. I mean, I'm using that as an example in the TV context, but you can always, that's how you kind of link them up. Or if you are an artist, let's say an art director or a graphic designer, then you would be, having the lead role for the company that you, work with, whether it's an advertising agency or, the client. You can also use that. And all of these are really based on your credits. The next one is record of major commercial or critically acclaimed successes. And again, they're very specific. So, it says as shown by blah, blah, box office receipts, motion picture or TV ratings. So usually, we use some sort of published either charts or box office results or album sales, or, if it's a television commercial, for example, if that commercial was broadcast during the Super Bowl and had, 5 million viewers, or, that kind of stuff. That's where you try and connect the either subscribers or viewers or ticket sales or number of YouTube views or anything like that. You try and tie it together with that in terms of showing that record of success. The next one is the most popular, is one of the ones that people always list first when they come to me. It's the reference letters, expert letters. Significant recognition for achievements from organizations, critics, government agencies, or other recognized experts. Everyone else basically falls under recognized experts. So these are really helpful, but I always say this, and I'll say it again when we talk about green cards, the reference letters alone cannot be the main source of evidence. USCIS doesn't like that. It's very, it's just not as objective, I think. And again, that's probably my my view, because and I say this to clients all the time, to know you is to love you. So getting a bunch of letters from people who you've worked with in the past is, it's helpful in one way to confirm your contributions to the company or your, your role on that particular short film or, whatever it was. But it shouldn't be the only thing that you have in terms of having this, recognition. So I try and, it's nice to have a few objective letters as well. So colleagues or peers in the industry who you haven't maybe worked with directly, it's good to have those kinds of letters as well. And the next one is has or will command a high salary or other substantial remuneration in relation to others in the field. So we used to be able to just send in some contracts and with the Department of Labor wages saying this is what other VFX artists, visual effects artists are getting paid in the Los Angeles area, and he's making substantially above everyone else. Now they want to be a little bit more specificity. So definitely contracts, just saying it isn't enough. We not only have to show your high payment, so that can be in the form of a tax return or a pay stub or a contract or something else, because it does say other remuneration, so other payment, and then to provide comparative wage data. So if you're listening and you're abroad, that would be, if you're an actress in Germany, for example, I can't give them SAG wages here in the U.S. as to compare if you haven't worked here. So I'd have to provide, obviously with your assistance, comparative wage data from Germany for that whatever that particular field is. So it doesn't just have to be compared to people here. It can be, the wages you've earned abroad as well compared to others in your country. So that's, basically those are the requirements. Of those 6, you have to show that you meet 3. My advice is, I always tell people we want to need to be as clear as possible on what you'll be doing and in what field in terms of the evidence. There is a lot of crossover in entertainment, especially with all of the new media that's out there. But the clearer you are, the better it is. The more confusing it is to the officer, the more, the stronger the likelihood of getting a request for evidence, or an RFE is what we would call it. So to be clear, try and document everything. Us just saying that you were, the cinematographer or like the editor of this short film that appeared at this film festival in China, for example, is not enough. Just saying it isn't enough. We need to have evidence of it. So whether it's a credit on the film or if it's a credit through or credit on a commercial, or if you're listed in the liner notes as being the keyboardist or the pianist on a CD, we have to actually tie it with some sort of piece of evidence. And then the backup is always the letters, which, like I said, it kind of fills in the holes wherever you can. But you want to evidence as much as possible. And then you try to meet as many of the criteria as possible in the hopes of satisfying at least 3, so that the reviewing officer sees that, in some areas you're going to have lots of evidence. In other areas, maybe you have only one piece of evidence, but it's super strong, so they still find that you meet that criteria. There's no magic number in terms of the amounts of evidence. People are always asking me, well, how much press, how many articles do you want? Or for models, how many tear sheets, that kind of stuff, or how many movies or TV shows or albums. There's not that. I don't have that, but it's all of the information about either the organization or the production itself. Those are the things that will add to the significance of it. So classifying for national, which occupation? Like I said, there's a lot of crossover, and nowadays everybody wants to do everything, especially in the entertainment industry. There's some, I've recently come across predator, producer, editor, writer, predator. I think that's what it is, or maybe it's I don't know, producer, editor, director. There are all these this crossover. Everybody wants, everyone wears a lot of hats. But what you should, focus on for the O1, again, for the officer, they want to know what it is. Your credits should match what you will be doing in the U.S. So if your credits, before were as a, let's say, as a model, for example, but you want to come here to act, it doesn't necessarily match up because you have to show you're an actor of extraordinary ability. So they're going to want to see a prior record of achievement in that field. So that's what they'll be looking at, and what will you be doing. And a lot of times you can choose. So I always tell people, look at your credits, and are you stronger as a producer? Are you stronger as a director? Are you stronger as a writer? Or are you stronger as an actress? Are you an art director? Or are you a graphic designer? So look at it that way, and then if you can, narrow the field even. Actor versus commercial actor, opera singer versus musician. Sometimes it kind of distinguishes you rather than being compared to, a huge pool of people. Then you're kind of being only, you're only compared to other people doing similar things as you. So it's a good idea to do that. And then, new media, I'll discuss that a little bit later. Everything's a little bit, soggy. So bloggers, they're writers, really, but they're bloggers. It's a different medium. Gamers, so recently that's come up, video game players. They've recently done some P visas, which I could have done an O1 for as well, had I, it just depends on the evidence, but that's a video game player. And then reality TV, is the person an actor? Is the person, are they appearing as themselves? I mean, that's a tough call to make, too. So anyways, there's a lot of ambiguity, but it's important to try and classify it. So the clearer you are on your credits, the better. Which standard do you fall under? Is it O1, under arts or motion picture TV? Again, we always have to look at what the person will be doing in the U.S. or what you'll be doing. Will you be working in motion picture TV? And my last point down at the bottom is, what if you're acting on a program, but it's not a TV program, it's not going to be aired on television, it's going to be aired online, which is obviously, very popular, like all these webisodes and things like that. And then also TV shows that are now just I say filmed, but produced, I should say, and only available and aired online on Netflix, like House of Cards. So that's not on TV. So is it the motion picture TV standard? I would argue no, because if you are going to do motion picture TV, you're required to get advisories. So we'll get to the consultations. So that's different. But if you're, a writer, for instance, not in motion picture TV, then you would just get a, consultation letter. And USCIS publishes them for each industry or occupation where the appropriate consultation comes from. So, but you need to make it clear, what you'll be doing, whether, what exactly you're doing. Okay, so that was those were the requirements in terms of your credits. I always tell people there are two parts. One is your credits. You have to qualify as a blank of extraordinary ability or extraordinary achievement. But two, we have to show that there's a petitioner, so a U.S. company that's going to sponsor you, and that you have some work or projects, upcoming projects. And again, focusing in on arts and entertainment, the petitioner is usually, so in general, petitioners are for the O1, it's employer specific. Contrary to popular belief, you can't self-petition. People, for some reason, think the O1 is a freelance visa. It's not at all. It's actually specifically stated in the regs that it's not at all. You can't self-sponsor, self-petition. And although it's traditionally for people who are self-employed, that's not the purpose, and that's not really what you can do. And they don't want to see speculative employment either, so they want to see that you have something. So as an employer, it can be a U.S. employer, a U.S. agent, or a foreign employer through a U.S. agent. So even if it's a foreign company, they still have to be, you still need a U.S. agent to file the paperwork. So employer as the petitioner is very straightforward. I give some examples here. So if you're the executive chef at a restaurant, I've done O1s for executive chefs at a restaurant. It's regular full-time employment. They're not, working at other restaurants or anything. Or if you're a VFX artist with, DreamWorks or something, then that's a very specific full-time employment. You need a contract, but you don't need an itinerary. Sometimes they'll ask if they're not sure what it is exactly you're doing, but you're limited to employment with that employer, and that's true generally in terms of immigration work visas. You're always tied to the employer. The next, so agent as petitioner is probably the most popular in the arts and entertainment industry, because that's where there are a lot of agents. People have agents who sponsor them. So let's say you're a writer. You probably have an agent that helps you find publishing deals and all of that. So that person could sponsor you, and then act on your behalf with other employers. Likewise, in the entertainment industry, actors and actresses and, comedians, all sorts of people, you have an agent usually, or manager. So that's where the agent is the petitioner, and this is the one that gets the most questions, again, because of that speculative employment. USCIS wants to know that you're here and that you're actually working. You're not here applying for jobs. You're not sitting here auditioning. They want to know that you're doing something. So in addition to seeing that contract with that U.S. Agent petitioner, kind of detailing the terms of representation, how much you'll be paid, and if it's not a set amount, if it's 20% commission goes to the agent, or whatever the terms are, there's no minimum amount. But they do want to see specificity, and then they also want, in addition to that, the itinerary of events, or kind of like the other deal memos showing what you'll be doing. And then later you can add additional events without filing an amended petition. That's a question people always ask. So it's not like you're set by those specific events either listed on that itinerary or the deal memos that you provide. Things fall, TV shows, productions, whatever it is, they fall through. That's the nature of the industry. But if at that time you do have those projects lined up, that's what you would provide. And if they do need to be changed, you can actually add them to the itinerary and to the petition later. What is an event? For the O1, so the O1 can be approved for up to 3 years at a time. We always apply or try and get 3 years if everybody wants that. But technically, USCIS has the authority. They can say that they're only approving it for the duration of the event. I always argue that the event is the contract. So as long as you have a contract, that's 3 years. It could be that, but it should be detailed in the petition, on the itinerary, in the contracts, to get as much time as possible. Again, with that contract, you want to make sure that there are specific dates there, how long you'll be performing in that role. Again, if you're going to be the producer, to have that there, how much you're getting paid. If it's $4,000 an episode, you're going to be the producer. It's going to be filming in Phoenix, Arizona. And then I always tell people, you want to factor in all of the other things that go along with taping or filming a movie or a TV show or a commercial, or if you're a musician, it's not just the performance or recording the album, but it's also writing. So pre-production, post-production, promotional events, any sort of publicity that you need to do in connection with the event. You can kind of link everything together, as long as the gaps, and I say this at the end, gaps between events are okay, as long as you can string them together. But, if you're here doing something and then you don't have anything for another year, it's really hard to link those things together to show. Okay, so we have you qualify, you have your evidence, you have your petitioner, you have your projects, and then as we're preparing it, we also have to there's a consultation requirement, and that depends on your field. So in the arts, again, this is all published on the USCIS website. They actually publish an index of advisories and for each industry, where you're supposed to get them. For most, for most industries, it's not as difficult. It should be from a national organization. So if you're a musician, I list here, American Federation of Musicians, AFM. If you're a VFX artist, it's the Visual Effects Society, and so on. And then for TV and film, they're very specific, and they're generally, generally nice, but also pretty tough because, they're protecting their members. It's a union that you're getting it from the management organization, which is typically AMPTP, Alliance of Motion Picture and Television Producers, but there's also the labor organization, which as an actor is going to be SAG-AFTRA, director is DGA, producer PGA. So they want to see they're the ones who really want to see what your work is going to be. They want to see the deal memos. AMPTP is particularly tough on the deal memos. They have a very specific format that they like to see, very specific information. You can go to AMPTP's website and go to the immigration section, and they'll tell you exactly what they like to see. Consultations are usually an additional cost of somewhere between $250 to $500. So you're paying them to kind of evaluate you, and then when they come back, it doesn't always have to be a positive consultation. They can say that, no, I don't agree. This person is not a writer of extraordinary achievement. Or hopefully they'll come back and say that, that you are. But this is required in the petition. So you have to request it. And even if it comes back, what happens in the event of an adverse opinion, even if it comes back as a negative opinion, that opinion is not binding on USCIS. And not just myself, but some of my colleagues here in our office have been successful in getting an O1 approved, even where one of the organizations said, no, we don't think this person is in, a blank of extraordinary achievement, and it's been fine. So, but it's something that you want to factor in. It takes about a week to get these as well, so timing-wise, something to remember. What are the basic filing procedures? Like we discussed, there's a petitioner. There's the evidence you want to get together, and then I should just mention really quickly, so for those of you who have a lot of evidence from abroad, any publications or press or articles or magazine covers, whatever it is, needs to be translated. We need to provide English translations for everything, and so that's something else to remember, and that would be nice of you to have ready before you ever get in touch with a lawyer to get started. It's always good to have the English translations first. They are time-consuming. You don't have to pay tons of money either. You can have somebody who's fluent in both English and the language of the documents, certify that it's true and accurate translation. So you're always going to need a contract or a deal memo, showing what the upcoming projects are going to be, consultation letter, or advisory. It really depends on the field. And then if the petitioner is an agent or manager, you must have a contract with the terms and sometimes itinerary. Most of the time itinerary, and if the petitioner is an agent or manager, It's just at random, but there have been a lot of requests for evidence in connection with these visa categories. So the documents, I've listed them here. There are forms, there's the petition, there's the letters, the evidence. You can either file it with California Service Center or Vermont Service Center. Is one better than the other? I file most of mine through California. Most people say that California is tougher on O1s, but I don't know. I think I just don't know any better, so I think it's fine. I do file through Vermont as well, but, I do think they're consistently random about their adjudication, so that's the only consistency I find. But it is based on, where you file it. You can't just choose, by the way. It's based on the location of employment, so if you're, in the entertainment, if you're, acting and your agency is in LA and you live in LA and you audition in LA, then it's going to have to be filed through the California Service Center. But if your agent is here in LA but you live and, audition and work in New York, then you could file through the Vermont Service Center. So that's that. Regular processing versus premium processing. Right now, the normal processing times are about 2 to 3 weeks. We've had some that have been approved in, 4 or 5 days, and that's just regular processing. So they've been really good. It did slow down for a little bit over the last couple of months, but it seems like I was actually just at the California Service Center last week, and they said they had received an overflow from other service centers of other types of cases. So I think that's why maybe it had slowed down a little bit, that it's back to being that. So I think that's good enough, because the regular filing fee is $325. The premium processing is an additional $1,225, so $1,225, but they will adjudicate your petition within 15 days. So for some people, just, they want the peace of mind. They want to be able to look at a calendar and know they'll have a decision by a specific date. So if anybody, especially if you have, if production starts on, let's say, it's going to be on December 1st, then to me it makes sense to do premium processing, because once you file it, you can actually contact premium processing and, tell them that it's, production starts on a specific date. You actually have an extra form of direct communication with the service center and the officer, whereas with regular processing, you don't have that direct line of communication. And by direct, I mean it's not like you can call the person like you used to be able to in the old days, but there is a premium processing email address, which comes in handy. So that's one of the advantages of that. But otherwise, timing-wise, it seems to be roughly the same. If you do get a request for evidence, by the way, under regular processing time, they don't really tell you. They just say within 30 days or 60 days. It just depends. But with premium processing, again, if you get a request for evidence, once you submit the response, another 15 days. So in that way, it's more definite, when you'll have your answer. Just some random tips for you. Save everything. I don't know in terms of who's listening, but I think it's always a good idea, in terms of who's listening and where you are in your career and your process. But it's always a good idea to save everything, anything that has your name on it. Everyone tells me, oh, I wish I had saved that, or I bet my mom has that somewhere, and you have to call mom in Australia and have her dig up that old box of newspaper clippings. So it's good to just stay organized and keep everything. And also, it's nice to get it while you're still friendly with people, because sometimes when time, as time passes, it's harder to ask people to write letters or to give you certain, pieces of evidence. So that's just my little point about that. In terms of, tips for filing an extension, typically if you just file an extension, if it's, to complete the same activities or events with the same employer, they'll usually only give you a 1-year extension. To get 3 years, you know, new events or activities, any changes at all, I mean, I think, in my opinion, you can ask for an extension of 3 years. They may or may not give it to you, but you can always request it because it may not be exactly the exact same, you know, productions or events that you're working on. If you're, you know, I don't know, if you're a musician, it may be different types of things that you're working on. And so for the 1-year extension, you're not really required to include updated evidence. They should, you know, they should approve it based on the previously approved O1, but I always recommend providing just a few things to show you've continued to work in your field. In the arts, if you're filing within 2 years of your last advisory, you don't have to get a new one, but in motion picture TV, they usually ask for new advisories. We have had some reports about erroneous visa denials or revocations or just problems in general at the consulates abroad. We don't know why. Hopefully that'll be resolved. But it is something where they can't really, once you file and your O1 is approved, you have to go to the, you know, unless you file it as a change of status here in the U.S., then you need to go to the consulate, have the O1 visa stamped into your passport. At that point, you have the, you know, the approval. The petition itself has been approved. USCIS has said, yes, this person is an alien of extraordinary ability. So at the consulate, they really should, you know, unless there's some sort of fraud, they should just be, you know, making sure that you are who you say you are and looking at to make sure that, you know, the visa can be approved at the consulate. So that's something to take note of. And then really quickly, and I'll talk about O2s in a minute, but the O2 is a good option, too, to think about. When you're looking at the O1, maybe you can tie yourself to an O1 and then later switch, yourself over to an O1 if you have, and in terms of time, too, it may be easier as an O2. Which I'll talk about. So O2 visas are for their essential support personnel in connection with an O1 artist or an O1 athlete. It's not available for in the sciences, business, or education. You're tied to that O1, so the O1 has to stay in place. So if they change or employers or if they leave, then your O2 terminates. But and it does require a separate petition, and you would be tied to, again, that person. You have to show that in the arts that you're an integral part of the performance, and you have skills and experience with the O1 in the past. So you would just show a pre-existing working relationship. In terms of film or TV, you would show the pre-existing relationship. So, for example, just to make it a little bit more tangible, if there's an O1 director and you want to do an O2 for his assistant director, who they've done a couple movies together. This assistant director knows the director really, really well, and the director really wants her to come with him. I would do an O2 for the assistant director rather than doing the O1 and going through all the criteria and evidence and all of that. Sometimes it's just easier to kind of piggyback on the O1. But again, you have to show a pre-existing relationship. Or, for example, if half of the film was filmed in the UK and they want to come and finish up, and do the rest of the film in, Austin, Texas or something, then you could get an O2 for the other crew members who had filmed, and it could be the cast and the crew members, everybody. You can actually get a whole, the whole production on a single O2 petition tied to that single O1. So that's really a great option. I think, let's see, like dancers, performers. I know we've done it for circus entertainer, I don't know what to call them, but members of the circus where there's one O1 and everyone else is tied to the O2, or Cirque du Soleil performers, we've done that as well. But again, you have to show that, some pre-existing relationship, or you're mid-production and you need to show continuity. The next visa category I'm going to discuss is the P visas. We're kind of actually running tight on time, so I'm going to go through this, I think, quickly so I can get to the green cards as well. P visas are for internationally recognized athletes or entertainment groups. So this is also a really nice option. I've done a lot of Ps for entertainment groups. So musicians, athletes aside, musicians are a great way to do the P. Or entertainment groups, if there's some sort of a group act. It's a 5-year visa. You have to show international or national renown, so it's slightly lower than the O1. And there are 2 regular criteria. You have to show that you only meet 2. And the criteria are very similar to the O1, but again, slightly lower. And the P1S is the support. So you can, like the O2 for the P, you can get a P1S. So you can get, the coach or the manager, or if it's a band, you can get crew members or supporting musicians who are not ordinarily a part of the band, but sometimes they perform on some of the songs, on tour or something like that. There's also P2 and P3, which are very specific. Again, so P1 is for the athletes, P2 or P1B is for the entertainment groups. If you're coming to perform as a member of an entertainment or musical group, and that they've been recognized, and for that one, you have to show that the band has been together. Well, here are the requirements. Actually, at least 75% of the members must have had a substantial and sustained relationship with the group for at least 1 year. So really it's just that I get this question a lot for bands because they're newly formed or they form here in the U.S. You have to show that at least 75% of the band members have been together for at least 1 year. So that's one of the main requirements to look out for. And then beyond that, it's just showing that they've, have some recognition, there's some press, some reviews about the band, that they've performed at certain, venues, and there's all sorts of specific evidence to give, and that, and then here it's important to note that individuals not performing as part of the group are not eligible. So that's something to remember. There's the P3, culturally unique. Culturally unique is very specifically defined. It's really something that has to be very unique to the culture, and coming specifically just to perform under a program that's culturally unique. The P1B criteria I've listed here. Again, it has the same, one-time achievement or 3 of the following, and it's about the group. It's the same stuff, so it's going to be, performing in a lead role, and then international recognition, so that's press, record of achievement, some letters, and salary. What do you need? Generally speaking, very similar also to the O1. You need all of the, form support letter, supporting documentation. The P1B also requires a consultation letter about the nature of events to be performed, and then you need to have evidence of a contract, again, between the petitioner and the beneficiaries, so, and the itinerary. A lot of the basic requirements as the O1. Okay, so what are some other visa options other than the O and the P, which are probably the most commonly, used, again, in arts and entertainment. But there is a B2 for amateur entertainers. The main point for there's the B2 and the B1. It can't be paid, and you have to, for the B2, you have to be an amateur, which nobody wants to admit to usually, but who is, it's a person who is an amateur is an entertainment or athletic activity, so that person is not a member of any of the professions associated with that activity. It's kind of hard to define necessarily, but you don't consider yourself a professional. And then the second requirement is that it's not paid. It's okay to get incidental expenses taken care of, and prize money. So if you're coming to perform as a competitor, then there's a $5,000 prize, then that's okay. But if there's a contract or you're being paid $10,000 to come and perform one night at a music venue, then that would be considered payment. So you wouldn't qualify for this. So you can't use this for that kind of a thing. And there are specific situations, for artists and still photographers and musicians under the B1 as well. You can get an E2 visa to run your own, like a production company. So if you're, a producer in France, you've done really well. You want to invest and open your own company here in the U.S., your own production company, and to continue to do what you're doing, you could do an E2 visa. For behind-the-scenes folks, there's the E3 or H1B, like for animators or graphic designers. For Canadians and Mexicans, there's a TN as a graphic designer. So if you're in that industry, the I visa is for journalists and bloggers. So that's another alternative. You do have to be, for the I visa, you have to be a member of the foreign media, and you have to be working for a media organization that has a home office abroad. So you can't be on an I visa working for a U.S. company. It has to be for a newspaper or a TV show or station from abroad. There's an H3 or J1, trainee or intern, for those of you who are starting out in the industry. I've done that for, for production kind of staff. There's an H2B visa for temporary or seasonal workers. That's if there are, especially for a group of people like an athletic team. It's a short perm. It's a little bit of a longer process, but it's definitely, it's another alternative if the person doesn't have the criteria or the standards that are high enough. The next option is the EB1. Okay, so now we'll get to the green cards, the EB1, aliens of extraordinary ability. It's a self-sponsored category, so hopefully you'll have an O1 and things are going really well. And then, I have clients who've been here for three or four O1s, and then they want to have they want to stay, or they want to have a more permanent status here in the U.S. is the EB1. It's very similar to the O1, but a much higher standard is what I always tell people. But you can self-petition, which is really nice, again, in arts and entertainment. Currently, it is a burdensomely high standard. As it should be. You're self-sponsoring. You're really trying to demonstrate that you're the top of the top. But, they're really looking at these very closely. So your evidence has to be really, really top-notch, I think. So you have to be basically, one of that small percentage who have risen to the very top of the field of endeavor. So they really want to see that you're at the very top. You have to show sustained national or international acclaim, and that achievements have been recognized in the field of expertise. Some evidence. So evidence includes one-time achievement, again, similar to the O1. So a major award, or 3 of the 10 criteria. So they're not, you're going to see the wording, the criteria may look, the same, it's not, but it is very, very similar. So chances are if you've had an O1, you probably have a lot of the evidence for the EB1. But here you have to really, really document and source all of the evidence. So here I wrote, source of publications, awards, company information, all of that. So prizes and awards, it's not just enough to say, oh, she won an Emmy award. I know it seems laughable, but they want to, you still have to provide information about she won the Emmy award for what. You should be named in that award. A lot of times they say a group award isn't you receiving the award. You were part of a team of people that won the award. They want to know what they want information about the organization that granted the award, who are some previous nominees, previous winners of that award, and then also whether it's national or international, and the nature of the organization too. So again, it's not just a copy of the certificate or a picture of you holding the trophy. They want to see all of the other things as well. Membership is another one. So, and it doesn't mean just you're a card-carrying member or a dues-paying member where there's no selection at all that anybody in the profession can be a member. It has to be membership in an organization where there's a selection process where you were actually selected for your excellence or for your achievements in the field. And then, again, same thing. It can't just be like a copy of your your Visual Effects Society membership. They want to know what the criteria for membership is, the application process, how people are selected, who the other nominees are, who are the judges, and again, more specific information. Published materials. Here, they do want to see that USCIS, when I say they, I mean USCIS wants to see that the published material is actually about you and not just the production. So this is hard for people who are behind the scenes in the arts and entertainment industry. Sorry, I got off track. And then they also want to see, again, not just a copy of the article or the interview of you, but also that it appears in, let's say it appeared in Variety. They want to know, who publishes Variety, what's the circulation, who's the intended audience, and information about the publisher as well, and then, what date it was published, who was the author of the publication of the article, and a nice clear copy of it. Participation on a panel as a judge of the work of others. So if you were asked to judge a competition, so let's say you were asked to judge, and this is just for, for kicks, but you were asked to judge, Dancing with the Stars, they want to see, information about the, organization, how the judges were asked, if you're, and what the prestigious nature of the organization is, who watched, what the impact was, and things like that. Original contributions of major significance. This, I think, is actually one of the hardest, or it's one of the harder ones, just because it's such an undefined, I don't know, it's original contributions of major significance. It sounds vague, and a lot of times it's very subjective, and I think they don't like to see it as well, but some arguments or some ways that they've come back to us has been to show, to evidence the impact of your work. So in the sciences, it's a little bit easier, because if you're a scientist and someone cites your work, that's easier. If you have a patent and someone, uses, uses your patented work, again, or a lot more straightforward. But in terms of other ways to show it in the arts or entertainment would be public commentary. So that would be press talking about your work and its significance. So in the same way that, the media picks up when Lady Gaga wears a meat dress or something, I mean, that's public commentary where they're talking about her and what she's doing. So public commentary is one way. Or if you have had, if you're a writer and your work gets picked up by the Associated Press and all these other various news organizations, to me that's, original contributions, because a lot of people, other people have picked it up. For musicians or artists, actually, in general, I think it's easier if you're a writer. Your original contribution, it's so easy to say that it's your original work of art. You authored it, or you wrote the lyrics of that song, or you did something in particular. So that would be an original contribution of major significance. Authorship of scholarly books or articles. So you writing an article, arts and entertainment is a little bit hard unless you're known as an expert in the field and you've been doing this a long time. Authorship, it would need to be of scholarly books or articles. So that's something to keep in mind. What is scholarly? USCIS has its own ideas, but they are pretty strict about that. But again, that's something, if you do ever get the opportunity to write about something or to blog about something, I mean, I would still include it as authorship. Because as an expert, you're being asked to write about your particular field. Excuse me. Display of work at artistic exhibitions or showcases. Usually, I mean, in the regulations it actually says, in the performing arts, but it's, you can possibly argue it in other things or in other areas as well. But let's say if you're a musician, to me that's performing arts, and you could argue that a music festival is where musicians showcase their work. Excuse me. So that's another one, critical or leading role. This is one that we saw in the O1 criteria as well. Highlight aspects that evidence your critical role. I mean, it's not just the title alone. The fact that you're a, let's see, producer. I mean, if you're the executive producer, when you have those kinds of roles, actually, it's a little bit more obvious. But if you're a, I'm trying to think, if you're like let's see, a VFX artist, you want to make sure that, that you're the lead VFX artist, even if the title itself doesn't say it. If you supervised, a group of 20, animators and designers, and that's you, that shows that you had a leading role, that you were kind of ahead of or in charge of all these other people. Even though you had a team of people, you were the lead. And then the last one, not the last one, next to last is high compensation and salary, which again, very similar. You have to relate, has to relate to the field. So use the Department of Labor statistics showing you're within the top 10% of the field. And I know it sounds a lot more onerous than it is. It's really not. But in addition to the Department of Labor, lately they, for whatever reason, it seems to me, don't even trust their own, it's the Department of Labor, so it's the U.S. government's own agency. They want to see other reliable evidence to corroborate the DOL statistics. So what we've been doing is including, media reports or things that you find online, career, I don't know what they're called, but let's say Monster, or, if Forbes publishes the top, wages or whatever it is. So you can get some independent, some media reports to corroborate it. And then again, if you can find some union or labor organizations, if you want to use foreign income that was earned, you would have to relate it to income, other people earning that income in that country. Last one is commercial success, how you contributed to the commercial success of the film or the TV show or the book or the museum if you're an artist, that kind of stuff. How many, if your particular artwork was sold and maybe the museum made a lot of money, you would show that you contributed to that. Or if you're a ballet dancer and that ballet was sold out, night after night. Those are the types of things. Usually it's money talks. And that's, to me, it's easier to show because you can always, it's nice, it's a very tangible piece of evidence to be able to get, and then you just have to tie yourself to that. My last point will be comparable evidence. I used to successfully be able to use that. USCIS will ask you why the regulatory criteria do not apply. Why as an actress, does the authorship of scholarly articles not apply to you? It's not enough, for it to just be obvious that most, actors don't author articles. They're not writers, they're not authors, but they want to hear you say it and explain why that doesn't readily apply to your occupation. So generally speaking, we only have a few minutes left here, but the EB-1 process is the two steps. One is the I-140 immigrant visa petition. That's where you're actually showing that you meet the requirements and that you are an alien of extraordinary ability. And this one, again, you can file regular processing or premium. The regular processing times, I'm right now really vary somewhere between 4 months. I've had some that went as long as 8 months, 10 months even. So it really depends. You can do premium processing, which means you'll get, either a decision or an adjudication or like a request for evidence within 15 days. Some people say that maybe there's a higher risk of an RFE or request for evidence. I don't know. I mean, I think if you have a strong case, it doesn't matter. If you're kind of on the fence, I think, again, it just comes down to what your particular circumstances, if you have, time left on your O-1 visa, or if some people, really want to, move forward with that second step so they can be able to work for other companies. So it really depends on where you are. But I don't think that there is a secret, formula or a magic answer there either. And then Nebraska versus Texas, same thing. I mean, you should really focus more on having a strong petition rather than, where you're filing it, or should you do it this way or that way, because then it becomes kind of, those magic, those 8 balls that you shake around. I mean, I don't know. It's too much guesswork to me. The second step, which you can file at the same time as the I-140, or you can file them separately. Sometimes people want to file them separately just because if Step 1 doesn't get approved, you can at least save your filing fees on Step 2. But, you can file them together. Once you do file the second step, that's where you get the EAD and advanced parole. So you get the work and travel authorization independent of whatever your current visa is. If you're here in the U.S., you can get that, which is kind of nice. If you're processing from abroad, that's here I have listed as IVP, that's immigrant visa processing. That's where you would start the process to be scheduled for an interview at the U.S. consulate abroad, and you would go that route if you're not currently here in the U.S. Some quick tips or some issues. There is there's obviously a lot of unpredictability. It's a very subjective standard, and although they say, that it's not, I think that it is because, we've all, clients always come, they've had a friend who, was only in like one movie and they got a green card and they didn't have any press, and then, of course, they come to me and they're like, I've had 10 credits and, tons of covers and all this stuff, and I didn't get approved. I mean, it just really depends, and it depends on the strength of your evidence, what your credits are, and then ultimately it depends on the officer who's reviewing your application, how well it's prepared, and how much evidence is there, and how clearly everything is laid out too. I think that has a really big impact on it too, the organization. Let's say you filed and it was denied. Should you reapply? I wouldn't just reapply with the exact same application. I would, I would go to an attorney, whether, it's our office or somewhere else. I would go and get a second opinion maybe to go over that denial and go over the evidence and see what you could do. Maybe there were things that could have been included that weren't. That's definitely happened to me in the past, where someone's come to me and I thought that, they left out some very pertinent and convincing evidence. Again, Texas versus Nebraska, premium versus regular, does it really matter? Not in my opinion, but there are a lot of people who, always file at, they say Texas is easier and they only, they only do regular processing. Premium processing will trigger an RFE. But again, I think at the end of the day, it comes down to how strong your evidence is. You need 3+ strong criteria and good evidence. Highlight the prestigious nature of the event, publication, media, use resources. Print out things from the company websites and as much information as you can. Don't assume the officer is familiar with popular culture. That's another big mistake people make, especially in arts and entertainment, or, we live in Los Angeles. I do. I mean, my 4-year-old son sees a billboard, every day and knows what certain things are, but, not all adjudicators are as familiar. And then also, I mean, it's just, it's just an easy way for them to say, oh, I'm going to request, they should have given this. It's a requirement, so you have to give information for NBC, Universal, or Disney, or what you just, again, can't assume they know what Pepsi is or that they know that Vogue is, a magazine with super high circulation figures. So document and evidence everything. Use, should you use regional or local evidence? The evidence, so let's say you're interviewed in a local paper, they may argue or come back with a request for evidence saying that it's regional and that it's not, major media, or so you need to show that it reaches national or international audiences. So maybe you can show maps or graphics that although it's a regional paper or that it's published regionally, it does have, there are subscribers. Let's say it's Canada, for instance, and it's published in Hamilton, like a suburb of Toronto. There are readers who subscribe to this magazine, and Canadian readers in Florida who read it. To me, that's international. So you kind of have to be creative, not in a fraudulent way, of course, but be creative in terms of really trying to get into the details of it. And then you have to address the Kazarian framework. What is Kazarian? Kazarian is this lovely case that made everyone's lives so much harder. So really, what is it? It's in the EB1 context. There was a case where basically kind of changed EB1 adjudications. We used to be able to just, show that you meet the 3 criteria, and it's approved, you move on. This case came out in 2010. Basically, in addition to that, there's the first part where you show, you demonstrate you meet at least 3 of the 10. And even if you show at least 3 of them are met, then they go on, the USCIS officer goes on to make a final merits determination. So then they consider all of the evidence, in its totality to see if you have sustained national international acclaim and that you're one of a small percentage who has risen to the very top of your field. So these are both very specifically defined, and you can read through the PowerPoint. I mean, the standard of, that to me, a final merits determination, it's very vague. It's so vague. So you can, say you meet 3, you meet 4, they can still say that based on the final merits or a final review of the totality of the evidence, they still don't find that, you meet, that you are of sustained national or international acclaim. And then the standard of review is preponderance of evidence, and more likely than not. Again, this is all very subjective. It depends on the experience, knowledge and training of the officer. Let me take a quick sip of water. Excuse me. So requests for evidence, if any of you have been through this process, don't take it personally. They're very, very common. Sometimes they're random. I have clients who are like, who they come back and they say, did you submit anything at all? Because they've come back and asked for everything. They say that I didn't meet a single criteria. And I don't know what happens, honestly, whether they've run out of time or, I don't know. But it does happen, and it's random. You have to read through the request for evidence carefully. Sometimes they're 9, 10 pages long, and I know it doesn't feel good to read all of that about yourself, to have them say that this isn't enough or that's not good enough. But you have to read it carefully because they have these templates where they have this pre-printed language, and they kind of fill in the details. Your details, sometimes there are mistakes. There are inaccurate statements of fact and law that need to be corrected in the response. Those are my favorites because you can actually, especially if they're misstating the law, I can always come back and say that. I mean, you have to, and your lawyer should always look at it. So if that's ever happened to you, really, want to read through it. What is the officer really asking for? Sometimes they apply the wrong standards. I mean, I would, not even sometimes, a lot of the times. Or they misstate things, or they confuse things, or they get it completely wrong. The one thing to note, though, is you can always explain, and you can only submit evidence that was there at the time of filing. I don't mean, not evidence in terms of like an article. Like if you find an article that if you filed on September 1st and that article was published on, August 29th, and for some reason you didn't have it, you can still add that. It's just you can't submit any new press after the time. Let's say you won and, I don't know, you land a big, huge movie role and then win an Oscar, but you already filed, you can't include that. So that kind of stinks. And then really quickly, again, my time has run out here, so if you need to go, feel free to log out, and you please email me your questions. There's an EB2 exceptional ability category. This is, so the EB1 self-sponsor, you don't have, an employer. The EB2 exceptional ability, it's if you have employer sponsorship, so it's only going to apply to some people. It's, a little bit lower standard. It requires a degree. There's a PERM process where you have to, follow certain steps. And there's a Sched A Group 2, Schedule A Group 2 category at the bottom with an asterisk. It's limited only to sciences and arts, so it's a good option, in terms of arts and entertainment. Good option for animators, visual effects artists. But it's not good for others in entertainment because you need employer sponsorship. Here I have the criteria listed. Again, you can find this criteria at uscis.gov. I just wanted to, this brings us to the conclusion. My email address is here, fwhittenberg@wolfstorf.com. I do prefer getting emails over phone calls just because that way I can get your credits, I can look at them. Feel free to send me any questions that you have. I'll try and also answer the ones that were here. And please feel free to give us any feedback about the presentation, and check back on our website. We do have other webinars if there are other topics that interest you, and we are available for other types of immigration workshops as well. Thanks to everybody who joined us, and have a great day. Good luck.